everybody. Good morning to those in the UK, and good afternoon and good evening for those of you joining us from everywhere else around the world. And welcome to our inaugural regulatory compliance event here in the UK. And in particular, a very warm welcome to our partners, CAMS, Cura and Archer. It's great that everyone's joining us here today as we take a bit of time to look at compliance in anti-bribery and corruption, and in particular on the Bribery Act following its 10th birthday. My name is Anthony Coyle. I'm Director of Strategy and Business Development and here at LexisNexis UK. I'm effectively product owner for regulatory compliance in the UK. So why is this important for us? So at LexisNexis, we are associated with legal products, and indeed our mission is tightly associated with the rule of law. But as well as serving the legal profession, LexisNexis and our sister businesses within the RELX group also serve several other professions in the UK. And this very much applies to the compliance profession too. As legal experts, we interpret legislation and regulations for thousands of lawyers every day. And through one of our newer content sets, regulatory compliance, we are now able to do this for compliance professionals as well. Our legal experts have created compliance modules across key regulatory topics and created a ready-made obligations register and alerting solution that can slot into your workflow and allow you to take control of your compliance. And indeed, you'll have a chance to see this content in action during one of the breakout sessions.
Welcome everybody to the session on the Bribery Act. As Tony mentioned, this is our inaugural session, and to sing happy birthday to the Bribery Act for its 10th birthday. I think before we continue and we talk to the panelists, it might be worth our while sort of trying to recall why the Bribery Act was passed in the first place some 10 years ago. And the main idea was to remedy some of the sort of perceived defects in the old law. In particular, what had happened previously was that criminalization was a confused mixture of statutory and common law offenses. We also had the problem where corruptly was being used, that the term corruptly was used but not defined. Consequently, what this meant was that there were different interpretations coming up for what corruptly means. And with that, added to the confusion that already existed. What has now happened is, of course, there's a moving away from this idea of using the terms corrupt or corruptly, so that because nobody understands what it really means, that's the general consensus towards which it's moving. We also had the additional problem that the statutory offences relied on the agent-principal relationship, which had its own difficulties and challenges. There was no specific offence for foreign bribery and a less than satisfactory definition of a foreign public official. And finally, of course, we had the ongoing problem, which still subsists today, which is prosecuting companies because of the common law test, the attribution test. And we'll come back to this later with the panel, which still continues to pose the problems. So what has the Act in essence done for us? Well, it's replaced those fragmented and complex offences. It's created two general offences covering the offering, promising, or giving of an advantage, and on the other side, requesting, agreeing to receive, or accepting of an advantage. It's created a discrete offence of bribery of a foreign public official. It's created a new offence with which you'll all be familiar, and that is the new offence of failure by a commercial organisation to prevent a bribe being paid for or on its behalf. However, as we know, it is a defence if the organisation can show that it had adequate procedures in place to prevent bribery. And more importantly for today and for compliance and risk professionals, it creates a risk-based approach for businesses. So to discuss the success or otherwise of the Bribery Act, I'm joined by a panel of experienced practitioners. So let me start by introducing you to the first member of our panel, Neil Swift, who is a partner at the Business Crime Department at Peters & Peters. Neil has an extensive experience in advising and representing individual and corporate clients in high-profile corruption and financial crime cases. Our second panelist is Martin Coyle, a barrister and former prosecutor who has had conduct of numerous complex and sensitive corruption cases and continues to serve as an anti-corruption expert on international bodies such as the UN and the World Bank, and he served as the UK's legal representative on the OECD Working Group on Bribery. And last but not least, our third panelist, Martin Coyle, a senior correspondent who is based at MLex's London offices and who, as part of his daily duties, reports on bribery and corruption issues in UK and Europe. So extremely experienced, and he was previously the senior editor at Thomson Reuters, where he also looked at and covered AML, financial crime, and regulatory enforcement issues. So with that experienced panel, you will see immediately that we have two Martins with us this morning. So gentlemen, with your permission, I will call you and address you by your full name so we know which Martin we are speaking to. So let me turn, Neil, first of all to you. Having heard, and as we know with the Bribery Act, where do you think it has been successful and where do you think it has failed?
Thank you, Arvinder, and thank you for the introduction. As you've said, the Bribery Act was aimed to simplify and modernise our anti-bribery laws, and it has done that. The offences that we now have are very widely drawn, and they make it abundantly clear that the paying and receiving of bribes carry serious consequences and is bad for business. It gets around one of the principal difficulties in holding companies criminally to account by the introduction of the Section 7 offence, which you've mentioned, the failure of commercial organisations to prevent bribery. So prosecutors no longer have the problem of needing to prove the involvement of a member of the board of directors in order to hold a company criminally liable for bribery offences. So I think there's been particular success in conjunction with another creature of statute that was introduced in 2013, the Deferred Prosecution Agreement. And for those of you who aren't familiar with that, a deferred prosecution agreement is an agreement between a prosecutor and a company to accept a penalty in return for not being prosecuted. And those agreements in the UK certainly have to be approved by a judge. And they have been used with considerable success. So there have been 5 DPAs for breaches of the Section 7 offence. So starting off with Standard Bank, which paid total penalties in excess of $30 million. Then a leap to Rolls-Royce, which paid total penalties in the UK of over 550 million. Smaller company, Guralp Systems, paid over £2 million. Airbus is the biggest so far, with total penalties of almost €1 billion. And then more recently, Airline Services, which paid a total penalty of nearly £3 million. The creation of the defence for organisations who do have adequate procedures in place has been another and perhaps the major success of the Bribery Act. And Martin Polaine is going to speak to you about that in a moment. Where has it failed? Well, that's really an issue of enforcement. So although there have been more than 90 convictions secured under the Act, the CPS has only secured 1 conviction against a company for a Bribery Act offence, and that was a dormant company, whilst the SFO has only secured 1 conviction against a company, and that was following a breakdown in negotiations for a DPA.
Interesting.
So I think moving over to Martin.
Yeah. So thank you, Neil. That's really helpful, I think, and we'll turn to the enforcement issue in a moment. Martin Polaine, can I just turn to you, please? I think one of the issues, particularly around the Section 7 and this risk-based approach that the Act sort of perceives and wants corporations to identify and implement their own programs, carry out their own risk assessments. what does this really mean in practice for an organisation? What are the practical steps that they should be looking to? So we understand the term, but how is it actually carried out in practice?
Thanks, Arvinder. Yes, it means in essence that an organisation has to have in place bribery prevention measures that are proportionate to the risk it faces. And of course, whether it's a small or a large organisation, whether its market is domestic or foreign, the level of that risk, the nature of that risk will vary. I'm sure as many people on the call know, guidance was issued under the Act. And one of the guiding principles, Principle 1, addresses the need for proportionate procedures. So those are procedures proportionate to risk, but also, and I think this probably needs stressing, proportionate to the nature, scale, and complexity of the organization's activities. So I think one has to bear that in mind. And when it comes to risk, of course, a key feature is conducting an organization-wide risk assessment. And I think one has to emphasize that a risk assessment needs to be rigorous. It mustn't be self-serving. And I think one of the pitfalls for a number of organizations is a reliance sometimes on the risk matrix. I think first of all, one has to say risk matrices have their part to play, but they risk, ironically, skewing the nature, extent, and profile of particular risks. So one has to be very careful. Also, I would say use a risk matrix to the extent one can, but don't rely on a generic one. Try to create your own risk matrix that reflects your sector, your client or customer profile, the nature of the business you do. And I think also remember that the procedures that should be in place and, of course, the risk you face is also going to depend on the type and nature of persons you deal with, you associate with. So, of course, if your business involves using agents or intermediaries, perhaps you're engaged with joint venture partners, you've got a subsidiary or subsidiaries, even your suppliers, they all raise issues. They all have to be considered by you when you're actually conducting your risk assessment. And I mentioned the principles set out in the guidance under the Act. Principle 3 is also important in this regard. It's the risk assessment principle. And what I would say, remember that due diligence, which of course is the exercise that many of those again on the call will regularly carry out or oversee. Due diligence has a twofold part to play. On the one hand, due diligence is very much part of risk assessment. Through due diligence, you'll identify, you'll measure risk, but also due diligence is a risk mitigation tool in its own right. So I think one has to remember that. I think the other thing to mention and perhaps to stress when one's talking about an organization's procedures is the importance of having senior management engagement. The essence of top-down involvement is stressed throughout the guidance. And I think that really does need to be taken on board. And of course, that comes with the need to have appropriate resources put in place, not just to assess risk, but also to address risk and to properly shape, in effect, bespoke procedures. And when you're looking at risk, look in the right places. There'll be inherent internal risks. There'll be external risks depending on geographical markets, depending on the nature of your clients and customers, of course, who you're dealing with. And do make sure you record and document your decisions, whether it's around risk, whether it's around the shaping of your procedures. I think one of the learning points the private sector can take from the public sector is recording and documenting. I think do that. You know what happens if you're unfortunate enough to find yourself in front of a court months or years later. Courts tend to take the view, if it's not written down, it's not recorded, it didn't happen, or you didn't consider it, you didn't direct your mind to it. So do record that. And I suppose, finally, the importance of remembering that this risk-based approach is not a once and for all. It's going to evolve as you evolve as a business, as you enter into new markets. So you have to go back to your risk assessments, conduct those, shape and amend your procedures accordingly. So I think, Arvinder, in a nutshell, That's what I would say on that.
Thank you, Martin. That's really helpful. Because what we're looking at is not just a review, a once and all review. We're looking at the duty to have a continual review as things change, as your markets change, as your own customer risk changes, and as regulations change. So with that, can I turn to Martin Coyle? Martin, one of the things is that organizations are having to deal with a lot of competing regulatory requirements and compliance requirements. So is there a risk that other issues such as anti-tax, AML is being ignored at the expense of the Bribery Act? Or do you think the Bribery Act takes precedence? Which way do you or would you guide our participants today? Martin Coyle, over to you.
Hi, thanks very much, Arvinder. I mean, it's hard to say whether these risks are being ignored. I mean, if you look at the number of Bribery Act cases in the last 10 years, as Neil said, there has been relatively few. I mean, we've certainly moved on from the first conviction, which I think was for a court clerk who was convicted of ripping up traffic offences. So we've certainly moved on, but there haven't been that many cases. But it doesn't obviously mean that companies are now whiter than white and are not paying bribes in these far-flung countries all around the world. I mean, what I think it has done, it's made companies sit up and take notice, and it's had two important effects. It's encouraged companies to sort out their compliance, as you've mentioned, and perhaps whether they do that with as part of their AML and general financial crime compliance, or they have a standalone bribery compliance procedure. That's something for companies to consider. But it certainly encouraged them to sort out those red flags and look into those areas that are the big risks, and certain countries and that they might operate in. And as Neil mentioned, the other thing is it's paved the way for this DPA regime, which can have serious consequences, financially and reputationally if they get caught out. Now, I think we're going to discuss later about, whether the SFO is enforcing that enough, and whether it has the resources to do that. But if you do fall sort of foul of the SFO, then you can be up for a very, very significant fine. So I think I don't think the risks are being ignored, but it doesn't mean that wrongdoing isn't taking place. I'm down at Southwark Crown Court quite a lot, and you see companies and individuals there all the time, for things that happened many years ago. So I think companies would be very unwise to ignore the risk. And if the SFO is not going to get you, then there's certainly a risk that the DOJ in the US will come after you. So it's important not to ignore these risks.
Absolutely, Martin, that's an extremely valid point you make around other jurisdictions reaching out. But let's turn back to our own jurisdiction. Neil, you very helpfully set out that one of the failings of the Bribery Act is actually the enforcement and the enforcement agency, the SFO. Can we just get a view and your view on why you think the SFO has not been particularly effective in enforcing the law? And what do you see happening going forward for the SFO in terms of making sure that the Act is being enforced?
Sure. I'm actually going to start with the positives before I indulge in a bit of SFO bashing. So I think that the law, and in particular the Section 7 offence, has enabled the SFO to secure outcomes, not convictions, but outcomes against major companies that it would never have been able to do before. Where you have companies that have diverse management structures, where there is a very, very huge gap between the senior level of management that could bind the company criminally and those who are actually carrying it out, it's incredibly difficult to prosecute companies. So I do appreciate that. And I think we're going to talk a little bit later on about what might generally change in that regard. I think the settlements with Airbus and the settlement with Rolls-Royce have demonstrated that the SFO, at least on occasion, can push itself into the same league as the major anti-corruption regulator in the world, the US Department of Justice. And we've had penalties which of the like we've never seen before being imposed in criminal courts, in a criminal context. I think where it's fallen down has been on the prosecution of individuals whose conduct caused their employers to enter into deferred prosecution agreements. So the SFO has prosecuted nobody in the Standard Bank case, in Rolls-Royce, in Airbus, or in airline services. And where it has prosecuted individuals following a deferred prosecution agreement for a Bribery Act offence, in Guralp and in Sarklad, the individuals were acquitted. And when one looks more widely at the use of deferred prosecution agreements to penalise companies before then prosecuting the individuals concerned, the SFO also failed to secure convictions of individuals in the Tesco case, and very recently in Serco, which was a case I know very well because I acted for one of the two directors who was prosecuted by the SFO following the company's DPA. And this really gives rise to the question of how well these cases are being investigated and presented, and whether the SFO's successors in negotiating agreements with companies, who of course are motivated to deal with a problem speedily, at minimum cost, and to put it behind them, hides a bigger problem with the SFO's effectiveness. So in my case, what was listed as a 12-week case collapsed after 4 because of some, well, on the face of it, because of some quite basic errors in disclosure, but in fact, probably a realization that the case was not a very good case. But nevertheless, you've got individuals put through this for very many years of their lives. So the sort of more, the question that you posed, is this going to change and when is it going to change? I'm afraid that I don't really have a crystal ball and I don't really know. So I can't really offer an answer to that. But all I can say is something clearly is wrong. You know, you've got deferred prosecution agreements, which on the face of it are a very good success for the SFO. But when looked at in another way, you know, are companies actually agreeing to signing up to something which, if the evidence were tested in a court, is completely unnecessary?
Yeah. No, thank you, Neil. Thank you. That's a really helpful sort of setting out where these failings are coming. Martin Polaine, can I turn to you on that? Given what Neil has just mentioned around the frustrations and the failings, if I can put it that way, about the SFO, if that is the case, that they're not really reaching what they're supposed to be doing, should organizations really trouble themselves with ABC policies and procedures? Or is the risk of a fine or punishment, certainly for individuals, so low that it's not worth the effort?
Arvinder, that's certainly a good question. I would say yes, but I would say that, wouldn't I? Yes, one should prioritize ABC policies and procedures. For a number of reasons. I think, first of all, of course, we've got to work on the basis that the "it'll never happen to me" approach doesn't always work and doesn't always bear out. One's got to, as a company, I think the unthinkable, because sometimes the unthinkable does happen. And of course, particularly in our pandemic or post-pandemic world, we know that all too starkly. Also, of course, even though the conviction rate's low, even though the chances of individuals being prosecuted and convicted is again similarly low, think of the upheaval that's caused to an organization if an investigation takes place, whether it's the need for an internal investigation, which can be expensive, which can be disruptive, whether it's then a full-blown criminal investigation with reputational issues, with knock-on effects in relation to commercial partners. So there's a lot at stake, and it's not just conviction. Also, I think one's got to bear in mind that we talk about ABC policies and procedures. One can't see those in real life, in isolation. One's got to have a dual focus. Some of the internal controls that the Act expects, the guidance expect, that we generally expect, are also those controls that organizations will want to have in place to address money laundering risks, the risks of dealing with sanctioned individuals, the risks of fraud, either within the company or externally. So I think one has to put the issue within the wider compliance and regulatory framework that a company has to have in mind. Also, of course, I mentioned commercial partners. Think of commercial partners. They will usually expect compliance by you. Remember the issues of the associated person under Section 7 and the Section 7 offence. One of the clever approaches of the Bribery Act, which I think is sometimes not mentioned, is that it creates for organisations the need to have this series of interrelationships and almost ABC interdependence. So I think one's got to bear that in mind as well. And as the other Martin quite rightly said, bribery and corruption is actually on the radar of prosecutors and law enforcement agencies, not just in the UK, but around the world. So have that in mind. And I think, although, as Neil quite rightly said, there have been very few attempts to prosecute individuals. Where they have, on the whole, they've not been successful. And the examples he gave, the Tesco executives with the accounting fraud, for instance, of course, there's not been success. Equally, though, in the recent past, the SFO has rather trumpeted the individual convictions in the Unaoil investigation concerning Iraq. And I think one has to say that looking forward, given that the SFO is conscious of the lack of convictions against individuals, that is likely to be something on their radar going forward. So as an individual, I would, within a company, I would say, be to some extent concerned preemptively about your position and protecting your position, as well as that, of course, of your organization. So in essence, then, Arvinder, yes, for all those reasons, do prioritize ABC policies and procedures.
Thank you, Martin. Martin Coyle, let me turn to you then very quickly. Having heard O'Neill and Martin mention the interoperability of ABC, AML, etc., how do companies or organizations, how do they stay on top of these changing rules and regulations, and which we know are getting more and more complex as time goes by rather than being simplified?
Well, thanks, Arvinder. I think obviously I would say they would do that by reading MLex and subscribing to LexisNexis products. But aside from that, I think if by looking at you can see the direction of travel with the SFO, as Martin has mentioned. Maybe there will be more of a focus on individuals going forward with these sort of failures they've had. But also, one way of looking at it, we can you can look at the speeches from Lisa Osofsky and what she's saying. I mean, we've seen a definite shift in approach from the David Green era, which was all about enforcement and prosecution. And he quite plainly said, we're not here to give companies advice. Whereas we've moved on to Lisa Osofsky, who's has a more sort of AML compliance background, and she's talking more about putting those compliance processes in place and you know, having these procedures in place. So, you know, these are something for companies to watch out for. I mean, we've talked about this foreign involvement as well. She's also she obviously comes from the US. She's got this US background. She's continuing to put this great store in this relationship with the US DOJ, which I think is fair to say, and MLex reported on it quite widely. It reached a kind of low with this Unaoil investigation, where there was this big battle between the prosecutors, which the SFO sort of ultimately lost out on despite its convictions. So I think that the direction there is these joined up investigations, joined up prosecutions, which we saw with Airbus and Rolls-Royce. And also finally, I think just to look at the types of cases that they're taking on, that gives you a good insight of where their priorities are. So they've taken on the Bombardier case, and they've taken on the Gupta case, and they seem to be taking on more of these, rightly or wrongly, more of these kind of investment fraud type cases. So, I mean, these are all pointers to where the priorities are going to be in the coming months and years.
Martin, gentlemen, time as ever is against us, so we have 2 minutes. Can I turn to each of you? One issue that's coming on the horizon that, in your view, is very, very important. Let me start with Martin Coyle, since we've got him here on.
Hi. Well, I think for the SFO, big importance at the moment. It's currently at the High Court, facing action by ENRC over its investigation into corruption that's been going on for 2013. It's a £70 million claim against them. So I think that is a big thing for the SFO, and it's going to have an impact on where it takes its ongoing corruption investigation. So obviously it could cost them a lot of money if it loses the case, but I think that's a big thing and something for everyone to watch out for.
Thank you, Martin. Neil, may I turn to you, please? One issue.
Sorry, the inevitable pause as I finally unmute. Not so much horizon scanning because it's already here, but we've very recently had the introduction of the Global Anti-Corruption Sanctions Regulations 2021, which enables the government to designate individuals or entities who they have reasonable grounds to suspect have been involved in bribery or misappropriation of property. So I'm sure many, certainly financial institutions, will already be very familiar with general sanctions, but this is yet another layer to the sanctions regime specifically aimed at corruption.
Absolutely. Thank you, Neil. And finally, Martin Polaine.
Yes, I think one thing immediately is early 2020, just before the pandemic hit, the SFO issued new internal guidance in its operational handbook around evaluating compliance programs. And again, with all the issues around the pandemic, that's rather sneaked past people's attention. The reality is, I think, the SFO is likely to be looking into compliance programs. Are they fit for purpose? With much more scrutiny. It's not going to be, in the SFO's words, it's not going to be simply a paper exercise. Just leading on from that very, very quickly. Also, I think organizations working in financial services and technology sectors are likely to be the subject of particular attention going forward. Thanks, Arvinder.
Thank you, gentlemen. Thank you very much for taking us through these very, very important issues and marking the Bribery Act's birthday. With that, can I hand over to Tony for the next stage?
So, as I said at the beginning, now going to move from problem to solution. As I mentioned, our legal experts here at LexisNexis have created this new product, Regulatory Compliance, a series of modules across key regulatory topics. They're ready-made obligations libraries written in plain English, and indeed Anti-Bribery and Corruption is one such module. Content can be immediately digested as is, or it's also available through our software partners, through the GRC solutions of our software partners. I'm delighted to have 3 of those partners with us today, CAMS, Cura, and Archer, who can show you a little bit more intimately in breakout rooms how this works. Thank you to our 3 partners for those presentations. We've obviously had a rich agenda today, looking at both the regulatory issues facing our businesses and our customers, and some of the solutions that we can deploy. Just quickly recapping some of the sort of key themes from earlier on the regulatory issues side. We start off with a bit of a history lesson and learn how the Bribery Act combines the disparate legal environment at the time into a risk-based approach, and then heard from the Martins and Neil that in order to be compliant, we need continual rigorous risk assessments that are not self-serving, and typically generic risk matrices are not sufficient. They need to be bespoke and nuanced in order to avoid prosecution and to avoid fines. And we have seen some fines, although enforcement has been mixed. The SFO has secured a number of good outcomes and settlements, albeit not convictions or individual prosecutions. And although investigations have been of varying quality, there's a sense that there may be more focus on individuals, and we heard about this concept of anti-bribery and corruption interdependence, which may be an angle of investigation in the future. And finally, sort of looking forward. Enforcement was very much a theme with the SFO, sort of more generally looking into compliance programs with more scrutiny, saying there's not just going to be a paper exercise anymore, and then more specifically in their ongoing case with the ENRC, at the moment. And then we also heard about the global anti-corruption sanctions regime on the horizon as well. And then as we moved into the breakout rooms on the solution side, we learned the value of legally reliable content and how valuable it is to integrate that within compliance workflows in order to reduce manual effort. So as ever, answers lead to more questions, and we will follow up these alongside some summary materials from the last hour. And finally, just for me to say thank you everyone for attending. I hope you've got some interesting nuggets to take with you into the rest of the week. I'm wishing everyone a good rest of the day or rest of the evening. Thank you very much.